well. So first off, a few key takeaway points for everyone today. As Emma was just saying, we are a national service, so we do take complaints from Australia-wide. I myself am based in Sydney, but Chris is based in Melbourne. We have colleagues across both areas, but we do take complaints across Australia. Our role primarily is to help individuals and small businesses to reach agreements with financial firms about how to resolve their complaints. Importantly, we're impartial and we're independent, and we don't act for either party to advocate their position. If a complaint doesn't resolve between the parties, we will decide on an appropriate outcome. And as part of that, the decisions that we make can be binding on the financial firm or insurers in most of these cases involved in a complaint. AFCA formed as a result of the merging of the previous ombudsman schemes, being the Financial Ombudsman Service, the Credit and Investments Ombudsman, and now as well the Superannuation Complaints Tribunal. And the AFCA rules expanded on the powers of those previous predecessor schemes and monetary limits, so that we do have a wider scope now as well. The intention of the new rules was to ensure that none of the powers of the predecessor schemes were eroded, but were expanded to assist us as much as we could. We can award compensation for losses suffered because of a financial firm's error or inappropriate conduct. With that though, and we will step through in a couple of later slides what our compensation limits are in that respect. We do have caps for the types of compensation we can award, but importantly, we cannot award compensation to punish financial firms or impose fines, but we do have the ability to award compensation for non-financial loss and stress and inconvenience that's been incurred as a result of claim delay or claims handling. We're a not-for-profit company that's governed by a board of directors, which includes an equal number of industry and consumer representatives. And the biggest thing, the message that we like to get across to people is that we are a free service. So for complainants to lodge a complaint with us doesn't cost you anything. So just be aware of that as well, that you can lodge the complaint yourself and deal with it through us for free. It doesn't cost you anything. We do our complaint resolution process, as I just alluded to in the previous slide. The primary objective for us is to try and resolve and negotiate complaints where we can. If we can't, then we do have the ability to provide our view or decision on a complaint. But when the complaint first comes to us, your complaint will be referred to one of our caseworkers. The team that I manage is a team of caseworkers who will be your point of contact and will discuss your complaint further with you. The caseworkers also guide you through our process and answer any questions that you have along the way. As this slide suggested, it goes through more of our process in a little bit more detail. So when the complaint first comes to us, regardless of where it's been already through the claim that you've had with your insurer, it will be referred to the financial firm for their response first. If they don't resolve it directly with you or come to a resolution, it will then progress through to our case management teams, who will then take care of you and guide you through the rest of the process. So often the biggest question is when to contact AFCA. So the key examples we give are if you're finding that you're unable to contact your insurer, or if you're unsatisfied with the response that you've been given. Either of those examples are times that you can contact us. If you're also unhappy with the outcome of your claim or the delays that you're experiencing with your claim, a proposed settlement that's being offered, or even just the service that you've received, you can definitely lodge a complaint with us. But in any respect, if you're not sure of whether you're eligible to complain or not, please give us a call or even go onto our website and have a look at our complaint form, and we can discuss that with you. Importantly, the message we want to get across as well is that lodging a complaint with us won't affect the processing or outcome of your claim, and you will also have 2 years from the date of the insurer's final response to you to lodge a complaint with us. If you're also waiting on a response from your insurer, you can still contact to discuss your complaint. But in the meantime, you might wish to begin gathering all of the information you have in relation to your claim. The more information we can be provided, the better. It just assists us in our investigation of the complaint once it comes to us. But again, don't feel as though that the complaint lodging process has to be daunting. If you've got everything that you need and you can submit the complaint with us, our case management teams can assist with looking at what kind of information will help us as part of our investigation as well. So that, again, the main messaging out of all of that is if you're not sure, just give us a call. Our staff can guide you through what might be the next best steps for you. In addition to that, we appreciate that some people have circumstances where they might need a complaint dealt with a bit sooner than others. We have urgent criteria that address those types of situations as well. So if your situation is affecting your basic living requirements, or if you're experiencing serious health issues, whether it be a physical or mental health condition, if you're experiencing financial hardship as a result of the situation that you're in, family violence, if you have vulnerable dependents, or if you're experiencing violent or threatening behaviour, these are all situations and examples that you can notify our staff of, and we can seek to have your complaint allocated urgently, so that we can make sure that it's dealt with in a timely manner for you. So that it is something that's asked of on our complaint form, and we'll go through in the later slides where that complaint form is and where you can find it. But definitely, if you're experiencing any of these or any other urgent situation, please let us know and we'll try and deal with that as effectively as we can. Okay, well, I'll hand over to Chris now and he'll run through the next few slides.
Thanks, Jessica, and hello, everyone. I'm just going to talk briefly, about our claim limits and compensation caps. So basically, AFCA's jurisdiction is that we can, as you can see from the slides, on the top blue one, that's the main jurisdiction that applies to insurance disputes, where you've got a dispute against your insurer. So we can deal with any claim up to $1.085 million, and we can award up to $542,500. Now, this is a per claim basis. So what that might mean that, say, for example, if you've got a building and contents policy and you've got losses that include both your building and your contents, well, it would normally be considered on a per claim, which is if you had like a $500,000 loss for your building and a $200,000 loss for your contents, we could award that amount because we would consider those as separate claims because they're covered under distinct sections of your policy. So similarly, with respect to, business policies or farm policies where you might have different sections of cover regarding, you may have your domestic residence, farm property and machinery, and they're all covered under distinct sections of the policy. Again, that would be considered on a per claim basis most likely and would fall within those jurisdiction limits. So there might be, even if you have a case where you might have an amount that's between our compensation cap and a monetary limit, we can deal with it because it's within the monetary limit, but we'll normally have a conversation with you first just to sort of explain how those compensation caps work and get an understanding as to whether or not, even if you were to get the best outcome at AFCA, whether that would be enough to resolve your dispute. Because obviously, if the difference is significant and that wouldn't resolve your dispute, then we may have a conversation as to whether or not we're the best forum. But typically, most people would be using that process because most likely the ability to pursue that in other forums can be timely and costly. The jurisdiction is a little limited. If you have a complaint against your insurance broker, that is only up to $71,000 in that particular case. I might discuss a bit about the types of issues we see. Thanks for that, Jessica. So probably some of the typical issues we would see at AFCA can be disputes involving the repairs or the cash settlement. So that can come up in these types of claims as well. These issues that can arise under that may be, disputes as to whether or not the insurer should do the repairs or should be providing a cash settlement. There might be dispute as to whether the scope of works that's being provided is sufficient to fix the damage. And there might be disputes as to whether or not the amount provided is fair or not. So in those particular cases, we would generally approach these issues in the following way. So most policies will give the insurer the discretion as to how they can settle a claim. And that might be normally they say they may decide to do the repairs or cash settle, but that discretion isn't absolute. We expect that those discretion is exercised fairly and reasonably in having regard to the particular circumstances of the complaint. So that might mean that in certain cases that if the insurer wants to cash settle, but the complainant wants to have them repair, then we might reverse that if we think that's fair in the circumstances to do so. And circumstances where that might come up is that we might have a particular complicated and large-scale repair issue. Complainants are particularly vulnerable, and the ability to try to navigate such a complicated process is just putting too much pressure on them, and there's no legitimate reason why the insurer can't undertake the repairs. And we also note that a lot of policies offer a lifetime guarantee as well, so there is definitely value in circumstances for the insurer to do it. But on the flip side, there might be circumstances when it is appropriate to cash settle. There may be a breakdown in the relationship between the parties. There may be issues that there are pre-existing issues in place that need to be addressed in order to warrant the works. For example, if you've got water damage into a property that's come through the roof, but the roof needs to have some maintenance work in order to keep it watertight, and that might be expensive, then in those circumstances, there might be a cash settlement is appropriate, because ultimately having the insurer do the works is not going to be worthwhile if there's another storm that could result in more damage. So if that's not an issue, then we look at, okay, is the scope of works in dispute or not? Because obviously that's, before we can work out whether or not there's a fair amount, we need to be satisfied as to what are the extent of works needed to fix the damage. So we would then look at the scope of works, and often we're going to be particularly guided by the experts on this. Typically, insurers will use engineers or building consultants to work out the scope of works. But often, that should be done in communication with the insured, to ensure that they've taken into account all relevant aspects. So we look at whether or not that is in dispute, and to the extent that it is, we review then what should be included. If once that's been done, then we look at what's been proposed as the outcome, and I'm going to talk a bit about a cash settlement outcome. So in that case, what we consider a fair cash settlement should be a cash settlement that's based on either the agreed scope of works or the established scope of works, and is a quote that, as we describe it, is actionable. That is, it can be actioned by the insured, by the person, that they can actually get that particular contractor or a contractor to be able to do the works that's quoted. And that's quite important in our approach to these issues, because to the extent that we're not satisfied by that, then we're not likely to consider that the offer is fair. We would, even if that we get to the stage where we're satisfied that ultimately whatever the offer is fair, what we typically also do is we add what we call a contingency to that offer. And that might vary between 5 to 25%, but it's typically between 10 and 20%. Now, what that is comprised of is usually that, in our experience and in the feedback that we've had, is that when you get to complicated repair jobs, it's inevitable that there are variances that happen during the repair. And that could be because you might find additional damage that wasn't evident from the initial inspections. You might find that during the works, more damage occurs. An example might be you might quote to remove certain cabinets or vanities and reinstate it, but in the process of doing so, they get damaged and then need to be replaced. So the more likely that there are variances to the works, the more higher that we would say that the contingency should be incorporated. And we also recognize that in a cash settlement, the risks of the works are being passed on to the insured or the customer, and they're also going to be losing the lifetime guarantee. So that's normally how we would approach those type of issues in terms of cash settlement or repairs. Because ultimately the objective is we want to be reasonably satisfied that the amount that's being offered will allow the particular person to get the works done for that amount. Now, on the next type of issue will be claims handling or delays. Now, that can come up typically for various reasons. Usually there's delays because of limited availability of contractors, trades, and materials, particularly if there's a large volume of claims. Our general expectation is that insurers should, and this is consistent, I should say, with expectations set out in the Insurers Code of Practice, expectations that are now imposed under legislation, that basically the insurer should do everything reasonably they can to expedite the claim and process. So what that might mean is that whilst there might be delays or in terms of issues in finding contractors or materials, we still want to be satisfied the insurer has done everything they reasonably can to expedite the process. So we talk about an approach paper for motor vehicle insurance claim delays. That's a sort of a good example. It may not be relevant because most often they're not going to be about motor vehicle claims, but some of the principles in that approach paper is relevant, because what we've found in some cases is that in some particular cases, insurers may just go to one particular contractor who says he's going to take X amount of time to find a particular part, and then it ends there. But in our experience, if you made inquiries with other contractors or other suppliers, they may actually be able to source the material sooner. So the idea is, have they made reasonable inquiries to ensure that there's no other way to source the relevant materials? There might be circumstances when they explored other options. Is there other different type of materials that might be suitable and available at the time? Have they considered other repairers that might be available to do it rather than through their normal panel of repairers? We would expect them to have considered those options. And have they been communicating regularly with their customer as to the issues as well, and done everything they can? So that's usually some of what we would expect, that there is a reasonable handling of the claim and doing everything they reasonably can to expedite it. I think Jessica mentioned that in certain cases we award non-financial loss. That often is an issue in consideration when there has been circumstances when an insurer hasn't handled a claim reasonably. And what we can award is around up to $5,400 in those circumstances. And that's based on whether or not we're satisfied that the insurer's claims handling or unreasonable claims handling has caused an unusual degree of extent or of inconvenience, interference, or delay. And the amount will depend on how egregious the conduct is. The more severe the conduct, the more likely, the higher it is. Or if the impact has been particularly significant because of the person's circumstances, then that will play a part as well. There might be cases we might award other types of losses if we're satisfied that there have been other financial losses that have occurred due to those claims handling or delays. And that's all I have to say on those on those relevant approaches. I might hand it to you, Jessica, about I think about best place to find the dispute form and other information.
Sure, thank you. So yeah, as I mentioned earlier, I've included on this slide our website for more information, our contact number should you need some more information, but there is plenty of information available on our website. It also has an online complaint form that will prompt you through and take you through the questions that form our complaint form. If you're not sure of that though, and you want some assistance, as I said, please feel free to give us a call. Alternatively, if you prefer to print it out and complete it, there's also a PDF form of the complaint form available on our website as well. But as I said, we do appreciate, and we've tried to give you a bit of a run through today as to what we do, but if there are specific questions that you have in relation to your circumstances and the claim that you might be going through at the moment, I've also provided my direct email and contact number, so please feel free to contact me directly. I'm more than happy to answer any specific questions after today as well. But otherwise, that was it. That's the end of our presentation.